At the conclusion of this lecture, you will be able to demonstrate a knowledge of the legislation governing the partnership, both unlimited and limited. You will understand the formation of a partnership, understand the authority of partners in relation to partnership activity. You will analyze the liability of various partners for partnership debts and understand the termination of a partnership and partners' subsequent rights and liabilities. Looking generally at partnerships, they can vary in size and formality. It is an informal association of two or more persons with the aim for profit. A partnership depends upon an existing relationship which results from a contract. A contract for the purpose of carrying on a commercial business, that is, a business bringing profit and dividing the profit in some shape or another between the partners. Many small family businesses are conducted in partnership. There are also professional or business partnerships with many members and elaborate management structures. The partnership is a means by which business people pool their resources and skills in the management of a business. A partnership relationship can arise only by mutual consent, which may be express or inferred from parties' conduct. The personal nature of a partnership means that a partner has agreed to associate with his co-partners and no one else. No new partner can be introduced without the consent of all the partners. In English law, a partnership is not an entity separate and distinct from the partners, who at any time may compose it. This means that the partners themselves are the foundation of the partnership and can be held liable directly for any losses caused by their actions. Therefore, when you sue a partnership, you sue the partners themselves. The firm cannot acquire rights, nor can it incur obligations. It cannot hold property. The rights and liabilities of a partnership are the collection of the individual rights and liabilities of each of the partners. The firm name is a mere expression, not a legal entity. Partnerships require much less regulation than limited liability vehicles, such as the company or the limited liability partnership. Partnerships also have the advantage of a large degree of privacy in financial matters. Additionally, there must be consent from all parties before a business decision can be made legal. A partnership is the relation which subsists between partners carrying on a business in common with a view to profit, per Section 1 Partnership Act 1890. Partnerships can be created orally, but partners often draw up an agreement in writing called Articles of Partnership, Partnership Agreement, or Partnership Deed. This sets down how the partnership is to work, and also the rights and obligations of each partner. The agreement can be changed at any time if all the partners agree to do so. As partners have unlimited liability for the debts which a partnership may incur, partners share joint responsibility for the entire amount of debt and other liabilities amassed by the business. Unlimited liability is not capped at a maximum amount and exists regardless of the amount of investment each owner has personally made. If the partnership is unable to meet any financial obligations or settle any outstanding liabilities, the partner's personal assets can be seized to satisfy the debts. This is in contrast to a limited liability structure, where owners' losses cannot exceed the total amount invested in the business. Any change in the membership of a firm, whether the withdrawal of a partner or the admission of a new partner, destroys the identity of the firm. The old firm is dissolved if the new surviving partners continue in partnership with or without additional partners. A new firm is created. The new firm can take over the assets of the old one and assume its obligations. This involves a contractual agreement between partners of the old firm and the new firm to continue the old firm's business. In addition, the transfer of an obligation will normally require the consent of the creditor. Continuing a partnership's business in this way does not continue the partnership itself. Even an agreement in advance that partners will continue to practice in partnership on the retirement of one of their number does not prevent the partnership which practices the day after the retirement from being a different partnership from that in business on the previous day. The ordinary partnership. This is the most common form of partnership, especially in small family-run firms. Ordinary partnerships involve potential unlimited liability for their members, should the business run into financial difficulties. It is possible to attempt to limit individual liability within the partnership by setting specific limits on the liability of the individual partners. This, however, has no effect on the external liability of the various members of the partnership, who will remain liable for the extent of the partnership debts. There are two special forms of partnerships: limited partnerships, introduced under the Limited Partnerships Act of 1907, and limited liability partnerships, introduced under the Limited Liability Partnerships Act of 2000. Although the names sound similar, they are very different. The Limited Partnerships Act 1907 allows for the formation of limited partnerships. The partnership must be registered with the company's registry. For members of a partnership to gain the benefit of limited liability under this legislation, the following rules apply. Limited partners are not liable for partnership debts beyond the extent of their capital contribution. In the ordinary course of events, they are not permitted to remove their capital. At least one of the partners must retain full, that is, unlimited liability for the debts of the partnership. A partner with limited liability is not permitted to take part in the management of the business enterprise and cannot usually bind the partnership in any transaction. If a partner acts in contravention to this rule, they will lose the right to limited liability. Limited partnerships have become popular in recent years as venture capital funds. Limited liability partnerships, LLPs, were introduced by the Limited Liability Partnerships Act of 2000 in response to worries of professional partnerships about being exposed to unlimited liability for very large professional negligence claims. Despite their name, they are in many ways closer to being limited companies than partnerships, and many of the provisions of the Companies Act 1985 apply to them. The limited liability of LLPs comes at the price of greater regulatory control to which general partnerships are not subject. The LLP is designed for professional or trading partnerships, for example, accounting firms. It enables partners who are actively involved in the business of their partnership to limit their liability for the partnership's debts and obligations. However, a partner may not enjoy the benefit of limited liability in relation to any negligent act which he commits in the course of the LLP's business. This type of firm has the right to hold property in its own right, the right to sue and be sued in its own name. It has perpetual succession and consequently an alteration in its membership does not have any effect on its existence. Most importantly, however, the new legal entity allows its members to benefit from limited liability, as they will not be liable for more than the amount they have agreed to contribute to its capital. To form a limited liability partnership, 2 or more persons must subscribe to an incorporation document. The incorporation document must be delivered to the company's registry. A statement of compliance must be completed by a solicitor or subscriber to the incorporation document. In conclusion, there must be express or implied agreement before a partnership can be created. There are 3 types of partnerships: ordinary, limited, and limited liability. Limited liability partnerships are more complex in nature.